I mean, if you're telling me that you're going to go to the sheriff's office and demand that they release him within 48 hours, I got to go upstairs and talk to a couple people to see how to go forward on this thing. Because I don't know. It's a new one to me, you know?
I'm not going to go behind the court's back, but...
Mr. Feldman, let me tell you something that, you need to be careful what you do. There is a fine line between zealously advocating for your client and doing something that either breaks the law, is unethical, that could get you in potential trouble. You need to be very careful.
Okay, pause. That was a major warning shot from the judge. When he says, "You need to be very careful," that's judge speak for "you're on thin ice, counselor." Feldman's push to get his client released might be noble, but it's skirting, dangerously close to misconduct. Would you take that risk if you believed the system was being unfair? Let me know below.
Good morning, Judge.
Hi.
I just want one thing I'll say. I have my client here on video.
Did you catch that moment of praise? Feldman's doing immigration work in a criminal court and impressing the judge while he's at it. Even the judge admits this is a first. You know you've disrupted the norm when the court pauses to acknowledge your hustle.
He can identify himself if necessary. I'm gonna just put my camera on, so.
This is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow.
This is,
Wow.
I don't.
Mr. Feldman, that's some good work, man.
I'm an
Great job.
immigration attorney, Judge, so I'm a salaried employee.
Yeah.
Really, great job.
Well, I just mean if I wasn't a salaried employee, maybe it wouldn't be worth my time. I think that's an issue.
But representation is representation, doesn't matter, really, at the end of the day, everyone is. Shh.
I don't believe that. I mean, I spoke to the ICE supervisor and even he said, I.
Well, hold on. We need to go on the record. Sorry, Miss Tom, give me a second. Are you ready, Ramona? Okay.
Order in the court, going on the record.
So, Mr. Feldman, what's the last name again?
Carl.
We're on the
All right.
record.
Have a seat, please.
Thank you. What's his last name again?
This is Cesar Moises Capriel Perez. I think he's listed as Moises Perez on the.
Moises Capriel Perez, Judge. I have a cause number.
Yeah, okay, let me have that,
Okay, it's
please.
529290.
Okay, all right, sorry, let's go on the record. All right. We are on the record. It is cause number 252-9290. Today is December 10th, 2024. It's approximately 9:44 in the morning. Parties, I'd like you to announce yourselves for purposes of the record, please. Beginning with state.
ADA Rojette Saba and ADA Kelsey Siegler here for the state.
And this is Noah Feldman on behalf of the defendant Cesar Moises Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well, before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit.
Judge,
I get.
if I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose. So what I just offer this to show that.
Is this his, or is this just a generic one?
Generic.
Okay.
Exhibit 4 is going to be just proof that he's in ICE custody. It's a print off the ICE.
That's 4.
Exhibit 4.
Okay.
Let's zoom out for a second. This whole list of exhibits Feldman's dropping? It's like a legal mixtape. He's building a layered case showing that the defendant followed the rules, paid his bond, and still got swept up by ICE. But here's the kicker. Most of these documents weren't even seen by the prosecution until this morning. Legal ambush or fair play, you decide.
Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
Okay.
Could withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standard ICE form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer, and it looks like I can see the defendant there, and it looks like he can look at us as well, but there's no translator, so does he understand what's going on?
That is correct, Judge. I do not believe he understands what is going on.
So now state, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket earlier this morning. I'm gonna need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day if you don't want to roll it to tomorrow, just like an hour or so I can read through it.
Sure, of course.
And that's-
And we did speak, or
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson.
Now here's where it gets legally murky. The judge is being told they don't even have jurisdiction to litigate immigration issues. Yet everyone's being forced to navigate the blurred lines between state criminal court and federal immigration enforcement. It's like trying to play chess and Monopoly on the same board. Should courts have more control in these scenarios?
I relayed defense's requests for an order of supervision, and the officer said he declined the request. He said that there would be no way that they would release defendant given that he is a flight risk and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before. He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. He also did say that the officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open. He's going to get deported, right?
That is my understanding.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge, if I may.
Okay.
Look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail shall not be required. Section 19, which says that no citizen of this state, I don't think they mean US citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, which is in Exhibit 2, which back after the ICE hold, the state requests $1,000 bond for the defendant. Defendant posted the bond and without any volition on his own gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition in our lot. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defect in the bond. If the bond is excessive, I don't see, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. We could set him at $1 million bond. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different bond. Now, as I said, the only bond that this court could set that would guarantee my client comes to court.
This right here is courtroom strategy at its finest. Feldman just flipped from objecting to a bench warrant to actually endorsing it, but only under one critical condition, that it doesn't revoke bond. It's a smart workaround to keep his client technically free while in ICE custody. High-stakes lawyering or clever loophole
Would be a bond that is impossible for him to post, right? Because any postable bond, he would have no control in getting to court. Now, ICE, if I may, Judge, I understand what Ms. Saba relayed that the ICE officer said, but I can tell you that 8 CFR section 241.5 allows ICE to release anyone on an order of supervision if they're subject to a final order of removal. If you look at Exhibit 1, the ICE detainer, it says that if you need this subject to remain in the United States for law enforcement purposes, you can call this number at 936-520-588, oh, sorry, that's the wrong number, 802-872-6020. And ICE can consider whether the law enforcement purposes are serious enough to keep the person in the country. Now, I think it would be punitive to take away $1,000 from somebody who posted a bond that this court affirmed, that the state requested, and say, I'm taking away your $1,000 because of actions completely out of your control, actions that are being taken by a third party.
So if I bench warrant him back here, then nothing will happen to that then, right?
A bench warrant is a revocation of bond, because if you bench warrant him, basically you're asking the sheriff to go get him, or you're asking ICE to bring him. ICE has already told Ms. Saba, we're not bringing him. The sheriff, if they go recover him.
No, they haven't said they said they were going to think about it, that they were going to look at it. They didn't say that they weren't going to.
Well, then let me clarify, Judge. If you want to bench warrant and be clear in that bench warrant that this is not a revocation of bond, I have no objection to that bench warrant.
Oof, the judge just dropped the favoritism bomb. And honestly, it's a valid point. If everyone else has to follow bond conditions, but this defendant doesn't because he's in ICE custody, is that justice or a legal exception too far? These are the gray areas that make courtroom drama real.
It's my opinion.
You had an objection last time to the bench warrant.
I have thought about it some more, Judge. If you bench warrant him, but there's no revocation of bond, I have no objection.
Well, then we're all happy.
But
Are you happy with that?
Yes, Judge, I'm
Great.
fully deferring to you.
Let's do it.
then let me say one more thing, Judge. I would request that on that bench warrant, it be clear this is not a revocation of bond. And let me tell you what.
Go ahead.
Because if you issue a bench warrant and there's no revocation of bond, the sheriff's office is not going to recover the body, because upon recovery of the body, they're going to have to release the body.